My name is Joe Zikas. I'm with NewHomeNotebook.com. I'm sitting here with Lloyd Gussis, who's an attorney who concentrates his practice in real estate. So we've got two big issues we've covered. We've covered certificates of occupancy and drop-dead closing dates. What other kinds of issues are you typically looking at?
Inspection issues on two levels. One is whenever there's new construction, the buyer's lender is going to have the appraiser go out right before the closing and determine whether or not the unit is substantially completed, and they will allow the closing to take place.
Substantially complete is a term of art?
Yes, and in the case of lenders, the term of art means the floors are done, the covering is on, the carpeting is in, all the appliances are in and hooked up, there are cabinets, there are countertops, the unit's painted. They don't care about punch list items, but if you get a situation where the cabinets are on back order, typically a lender won't allow you to close. Now, the problem is that the contract itself says when the seller tells you that the unit is substantially completed, he'll give you a notice of closing. He doesn't care at that point whether you have a lender, who your lender is, what your lender's requirements are. So what ends up happening is, and this happened to me many years ago.
Typically you're suggesting you're not going to have your loan lined up at the time of your contract looking at 6 months out or
You've hit one of the problems that people need to understand when they buy new construction, because the seller gives the buyer 30, 45 days from the date the contract is signed to get a mortgage commitment. After that, the buyer's in the deal. End of discussion, the buyer's in the deal. And if the unit's not going to be ready for a year and a half, obviously you have a commitment for the money without an interest rate, with everything having to be rechecked down the road. So it causes a problem for the, it could cause a problem for, you actually don't have a commitment. And a lot of people, what they've done is basically, they get a pre-approval letter and they're fine with that and they'll deal with it when the time comes. The problem is, once you let the mortgage time go by, the contingency time, you are in a risk situation, because if you then don't close, and again, you're seeing a lot more of that now, where people have bought units 2 years ago and can't get the mortgage to close now, their earnest money's in jeopardy.
What kind of earnest money are we looking at?
Usually 5% of the purchase price. So if you're talking about a $400,000 place, it's $20,000, which is not chump change.
It's an option price.
Yeah, that's exactly what it is. That's exactly what it is. So getting back, I had one many years ago where, I'll never forget, it was Citibank, went out and did a final inspection. And they said something wasn't done, I don't remember what it was, and they would allow the closing if $3,000 was held in escrow until that item was done. And I was the buyer's lawyer, and as the lawyer that I am, I looked to the seller's lawyer and said, my lender will allow me to close, but he wants $3,000 because you guys haven't finished whatever it was. And he looked at me and probably said what I would have said to him had I been in his shoes, and said, what does it have to do with me? It's your lender, you deal with it. So the buyer was in a situation of not only having to close the deal in order not to be in default, but putting up the money to guarantee that the seller was going to do the work after the closing. So what I typically will put in my contracts or in my letters, and sometimes it's successful and sometimes it isn't, is that the parties acknowledge that the buyer's lender is going to do a final inspection prior to closing, and if the lender determines that the unit is not substantially complete, or requests an escrow that the seller is not willing to fund, that the closing will be extended until the work is done and the lender approves. Now, for me, that's exactly what happens. The problem is there are sellers or sellers' lawyers who, again, don't want to know about it. It's not our problem, it's your problem. And the fear, of course, is that you get the crazy lender who says, I know I'm lending on unit 2, but the backyard area is not sodded yet, and we won't allow the closing to take place until the backyard is sodded. And when you tell them that it's January and there's 2 feet of snow on the ground, they don't necessarily want to hear that. So a lot of times we tweak that a little bit and say, you know, reasonable, lender has to be reasonable, it has to be the unit only, and I'm fine with that, because then you talk to your lender as you go along.